This is Michael Spielberger Jr. at Spielberger and Buzzelli. In addition to handling your real estate needs, we also offer estate planning services. Pretty streamlined process to get this done for you. First, we start with an initial consultation where we gather some information from you, whether it be drafting a will, living will, medical power of attorney, financial power of attorney, or any trust agreements. We handle that for you. And how can we help you during your lifetime, and how can we help you after your lifetime? Determine the best way to move forward. Will is a legal document, describes how you want to pass your property to your loved ones after you pass. Estate planning is important because it makes it easier on your loved ones. It shifts the burden from your loved ones when you're passed away from them in that moment to you having these decisions made in advance, so they don't need to worry about how your assets are going to be distributed. There's no fights between family members. You get to say during your lifetime, this is how I want it to be distributed. If you pass away without a will, file probate with the county clerk's office. Go to the court. They'll give you some documents passed through New Jersey intestate laws. A nightmare scenario we just had recently in real estate. Grandfather and grandmother both passed away. Grandmother passed 4 years ago. She left the will, but they never probated the will 4 years ago. Looking to sell the property that was owned as tenants in common between the grandmother and grandfather. So when the property was trying to be sold, it got flagged and titled. That grandmother that passed away 4 years ago still had an interest in the property. So we had to backtrack 4 years ago, get everything probated. It added a couple months of time and delays in the closing, where they weren't able to close on time, and it brought up some extra costs that people don't really think about. As part of the estate planning package, we draft 3 separate documents for you: your living will, medical power of attorney, and then your will or any trust agreements. How can I set up a will to avoid any taxes? First thing you want to think about is your federal taxes, which is 40%. You're exempt up to, currently it's a little bit more than $12 million per individual, and that would be a little bit more than $24 million per married couple. So a lot of people don't have to worry about federal taxes unless they're over that amount. New Jersey, there's no estate tax, there's an inheritance tax, or depending on your relationship to the deceased. Another thing to consider is if you have any minor children, you can set up a minor trust in your will, where you would appoint a trustee to handle the assets or money given to these minor children until they reach a certain age. Also protect your assets through trust in your will. For example, if you have a child who's married and then later becomes divorced, you can set up an inheritance trust that would protect your assets from going to an ex-spouse. If you're concerned about giving a child a lump sum of money when you pass away, you can also set up a trust to protect that child from creditors or spending too much of your money. You can have the assets distributed at a certain period of time when they reach the age of 25 or 30 or 35, however long you feel necessary. So when you finish your will, you only want one original copy. You can make copies. That's not necessarily going to be accepted by a court. It has to be the original will, so you want to leave the original will in a safe place, whether that be a safe deposit box where you can leave it with your attorney. The will will be stored, and where we can strategize the best way to transfer those assets to your children or your loved ones or any beneficiary, or avoid probate or any tax strategies during your lifetime. Your financial power of attorney and medical power of attorney. Who do you want to make medical decisions or financial decisions on your behalf in the event you're unable to do so? If you become incapacitated, who do you want to be able to sign your name, to send title, your assets to another person, to sell those assets for you, to open a bank account, to file your taxes? A lot of people like to look at the living will as a way of relieving loved ones from making those hard end-of-life decisions. You get to determine how you want that to be handled, and then your loved one would follow those instructions. What happens when you die? Generally, if you're married, your assets get transferred to your spouse, or you have a trust set up where all your property goes to the trust. What happens when you both die? Generally, it gets left to your children. If you have minor children, you should be aware that a guardian or a trustee for those assets should be established in your will or your trust. If you have any questions about, feel free to reach out to our office.